Welcome back to the Deep Dive. Today, we're going to really dig into something fascinating in tort law. How do you prove someone was negligent when, well, all the proof seems to have vanished? Or maybe it was even, hidden or destroyed by the very party you're suing. So our mission here is to figure out how someone recovers damages after something like a big fire caused by, say, a power line, when the power company controls all the information and just doesn't give a clear story. It sounds like the deck is totally stacked against the person who suffered the loss, right?
It absolutely does. And that exact kind of information imbalance is why the law developed the doctrine of res ipsa loquitur.
The facts speak for themselves.
Exactly. It's Latin, but the idea is simple. It's a crucial procedural tool when you don't have that direct smoking gun proof. RAL basically says, look, based on the type of accident, it's fair to infer negligence, and it kind of forces the defendant to step up and explain what happened. So our deep dive will follow the framework laid out in some key cases like Roberts and the one we'll focus on, Koch. If the plaintiff can check off the boxes on a specific three-part test from those cases, they get their day in court. A jury can then decide if negligence is the most likely explanation, even without, say, seeing the faulty part itself.
Okay, let's unpack that. Why is res ipsa? Why is it seen as an exception? Normally, the plaintiff has to prove every element, including the breach of duty.
Yeah. That's definitely the general rule, yes. But res ipsa isn't changing the substance of negligence law. Think of it more as a rule about evidence, specifically circumstantial evidence. It's a procedural helper. It applies because, let's face it, some accidents just scream negligence, like a chandelier falling in a ballroom or a sponge left after surgery. The idea is the accident itself makes negligence seem more probable than any other story the defendant might spin.
So it stops the defendant from basically saying, yeah, we know how it happened, but we're not telling. And since you can't prove it specifically, too bad for you.
Precisely. It helps level that playing field. Otherwise, companies could potentially avoid liability just by keeping tight control over their records, or, as we'll see in the Koch case, maybe even getting rid of the key evidence.
That really raises the stakes. Okay, let's put this doctrine to the test with Koch v. Norris Public Power District. This seems like a perfect example. First off, what are the legally dispositive facts?
Right, so this happened back in 1996, out in a Nebraska cornfield. Verdell Koch and his wife sued the Norris Public Power District because one of their high-voltage power lines snapped and fell onto the Koch's property on October 26th.
And it wasn't just a fallen line.
No, definitely not. It sparked a huge fire, burned up something like 86.6 acres of corn, plus other property. The damages were calculated at over $41,000, which was significant money then and now.
And what about the lead-up? Did anyone see anything wrong?
Well, Mr. Koch had actually seen the line just 2 days before, and he said it looked fine. The weather on the day it fell, it was sunny but windy. Norris pointed to the wind about 40 miles per hour, but the court later clarified that wasn't, extreme weather for the area. And here's the really critical part. Norris admitted their line fell, and yes, it caused the fire, but, and this is a big but, the broken piece of the power line itself, the physical evidence, it somehow ended up in a dumpster and was destroyed after Norris supposedly did some undisclosed testing on it.
The key evidence just vanished. Okay. Given that, and the fact the trial judge initially threw the case out before it even got to a jury, a directed verdict for Norris, what was the core legal issue for the appeal court?
The central question was pretty focused. Does the doctrine of res ipsa loquitur apply here? Could the coaches use it to make a basic case, a prima facie case of negligence against Norris, strong enough to actually let a jury decide?
Got it. So before the appeals court could apply the facts, they needed the legal standard. What rule of law did the court use? Can you state the full rule and break down its parts, the test elements from that Roberts case you mentioned?
Sure. The court went right to the established three-element test for res ipsa loquitur. To use the doctrine, the plaintiff has to show three things. First, element 1, absence of negligence required. The event, the accident, it has to be the kind of thing that usually wouldn't happen unless someone was negligent. Second, element 2, exclusive control. The thing that caused the harm, the instrumentality, here, the power line, it must have been under the exclusive control and management of the defendant, the party being sued. And third, element 3, absence of explanation. There has to be an absence of a real, plausible explanation from the defendant about how the accident happened without their negligence.
Okay, thank you. That's clear. Now, for the court's elemental analysis, let's walk through it element by element, just like they did. How did the court apply that first element, the idea that this kind of thing doesn't happen without negligence?
Right. So the court looked at common sense and legal precedent. They found that generally, courts agree. When wires carrying dangerous amounts of electricity just break and fall, it does raise a presumption of negligence. They specifically tackled the weather issue, finding 40-mile-per-hour wind wasn't an act of God or something totally unforeseeable.
But hang on, 40-mile-per-hour wind isn't exactly a gentle breeze either, especially for something high up like a power line. Why the quick presumption?
That gets to the core of RAL's policy. The court actually pointed to testimony from Norris's own engineer. His name is Pollard. He admitted under oath that power lines don't just fall down on their own. Something has to cause it. The principle applied was basically, if you put something heavy or dangerous way up high, you're expected to build and maintain it so it stays there under normal conditions. Since this line fell without extreme weather or some obvious outside force, the most likely inference, the court decided, pointed towards negligent construction or maybe poor maintenance. So, element 1, check.
Understood. Utilities have to plan for normal weather, essentially.
Hmm.
Okay, now what about the second element? Was the power line under the exclusive control and management of Norris?
This one was pretty straightforward for the court. Norris put the line up. Norris charged it with high voltage. Norris was responsible for maintaining it. Their engineer even admitted that customers don't climb the poles. It was Norris's job. The court basically scoffed at the idea that anyone else realistically had control over that specific line, way up in the air, carrying dangerous current.
They said imagining someone else messing with it, short of maybe, shooting at it, was ridiculous.
So exclusive control here doesn't mean literally no one else could possibly interact with it ever, but rather that Norris was the party responsible for its safety and upkeep.
Exactly. It's about who has the responsibility, the duty of care, and crucially, the superior knowledge about its condition and why it might fail. Norris clearly had that. So for RAL purposes, they had exclusive control. Element 2 met. Okay, that brings us to the final, and it sounds like the most contested part, the third element. Was there an absence of explanation by Norris? This is where the missing evidence in Norris's defense theory collide, right?
Precisely. This is where Norris tried to push back. They didn't offer a concrete explanation, but they threw out possibilities. They suggested, well, maybe vandals damaged it, or perhaps hunters shot the line.
Just floated theories?
Yeah, theories without backup. The court called this explanation weak at best. And this is key for RAL. The explanation offered by the defendant has to be more than just speculation. It needs some factual basis to actually counter the inference of negligence that arises from the first two elements. Norris couldn't point to any reports of vandalism nearby, and the court was skeptical, let's say, about whether the kind of guns typically used for hunting squirrels or doves in the area could realistically bring down a high-voltage power line. Given that Norris also conveniently couldn't produce the broken line itself for inspection, well, the court found their speculative finger-pointing wasn't enough.
So the court is saying, if your explanation is basically a wild guess, especially when you're the one who controlled and then lost the evidence, that guess doesn't automatically get you off the hook. The jury still gets to weigh it.
That's exactly the point. A weak, unsupported explanation doesn't kill the RAL inference. The court decided that letting Norris win just based on an unproven maybe hunters did it claim would be wrong. The credibility of that explanation was a question for the jury, the fact finder. Element 3, therefore, was also satisfied in the plaintiff's favor for getting the case to the jury.
Okay, so after breaking down all three elements and considering those, frankly, troubling facts about the evidence, what was the court's final conclusion?
The appellate court concluded that the Koches had successfully established all three elements required for res ipsa loquitur. This meant the trial judge made a mistake in granting that directed verdict for Norris. It essentially punished the plaintiffs for the lack of evidence that Norris itself was responsible for losing. So the decision was reversed and the case was sent back down remanded for a new trial where the Koches could actually present their case using the inference of negligence to a jury.
That's a really significant outcome. It shows RIL isn't just theoretical, it has teeth, especially when information control is so skewed. Let's try to make this even more memorable, especially that third element about weak explanations. How about this? Picture a busy city street. A pedestrian is just walking along, minding their own business, when suddenly this huge 50-pound municipal manhole cover, the kind bolted down, shoots 100 feet straight up in the air like a rocket and lands, injuring them badly. Later, the city, which, exclusively manages the sewer system, claims the only possible explanation is that a single, unusually large badger must have run at full speed and somehow hit the cover just right to launch it.
Okay, that's vivid. And perfect for illustrating element 3. So let's run it through the test quickly. Element 1. Manhole covers launching 100 feet. Yeah, that doesn't happen without negligence. Check. Element 2. City exclusively manages its sewer system and covers. Check. Now, the Badger explanation. The city did offer an explanation, didn't they? But remember, RAL isn't defeated by any old story. It has to be a plausible explanation that reasonably counters the inference of negligence. This Badger theory, it sounds about as plausible as the unsupported Hunter theory in Koch. It's pure speculation, bordering on, well, the absurd.
So if your defense sounds like it came out of a cartoon, you're probably not meeting the bar for a credible explanation under element 3.
Pretty much. That kind of fantastical, unsupported explanation wouldn't defeat RAL as a matter of law. The judge would likely say, okay, city, you can try to convince the jury about this Badger, but the plaintiff still gets to argue their inference of negligent maintenance is the more likely story. It goes to the jury.
This whole discussion really, from the power line falling to Badgers launching manhole covers, it gives us a great template for someone trying to apply this. If you, the listener, are looking at a scenario on an exam or even in practice, and it feels like one side has all the info, what's a practical step-by-step checklist for spotting and applying RIL?
Okay, yeah, we can synthesize this into a diagnostic checklist based on Koch and the Roberts rule. 4 steps. First, issue spotting. Does the situation involve an accident that's kind of unexplained? Something fell, broke, escaped. And does the defendant seem to have way more knowledge about what happened because they controlled the thing that caused the harm? If yes, red flag for RIL. Second, test 1, ordinary course negligence. Ask yourself, is this the type of accident that normally happens if people are being careful? If it's something like a power line falling in moderate wind or maybe surgical tools left in a patient, the answer is likely no, meaning this element is probably met. Think, should proper repair prevent this? Third, test 2, exclusive control. Ask, who was really in charge of the thing that caused the injury? Who maintained it? Who had access? Who had the duty to keep it safe? Look for facts showing the defendant had that primary responsibility and control, not really the public or the plaintiff. If so, check. Fourth, test 3, explanation credibility. Okay, did the defendant offer any explanation for how it happened without their fault? If they didn't, element met. If they did, now you have to really scrutinize it. Is it backed by any facts? Or is it just guesswork, speculation, like the vandalism claim in Koch or a friend the Badger? If the explanation is weak, unsubstantiated, or just doesn't ring true, the RL inference likely still holds and the case should proceed.
That's an incredibly useful framework. It really drives home that Koch wasn't just about a specific set of facts, but about the principle of procedural fairness. RAL stops a defendant from benefiting, essentially, from their own control over or maybe even destruction of the evidence.
Exactly. It's the law recognizing that sometimes fairness requires allowing an inference when direct proof is impossible for the plaintiff to get. Okay, so here's a final thought for you to chew on, building on Koch. What if Norris hadn't destroyed the power line? What if they did conduct testing and the report came back showing a specific documented failure, say metal fatigue caused by a hidden defect from the original manufacturer? How would that specific, factual, potentially non-negligent explanation by Norris affect the third element of RAL? Would the court still have sent the case back for a jury to consider the inference of general negligence? Or would that specific report, even if pointing elsewhere, have effectively rebutted the RAL inference, forcing the Kochers to then prove some other specific negligent act by Norris, like faulty inspection? Think about how a concrete, alternative explanation changes the dynamic.